Okay, it looks like we're ready to go. So I will start with an introduction and speakers. If you're not in this first section, if you could turn off your cameras, that would be great. Great. So welcome everyone. We're so excited to have you here this evening. Welcome to the New York Law School Symposium on ADR and Diversity. We have an exceptional, exciting, and engaging slate of speakers this evening. So just a few housekeeping comments. For those seeking CLE credit, you should have received a link to the CLE certificate earlier this week. And I think the link was sent out again earlier today. Over the course of tonight's event, I will share 6 code words. Please write those down and also make sure that your name on the Zoom screen or on your screen, I mean, we can't necessarily see all the participants, but matches the credit, your name for the credit. Um, as the night progresses, we ask that you remain muted. Um, Not so much of an issue with webinar, but just FYI. And we do encourage you to submit your questions through the Q&A. We may not have time to get to all of them, but we'll try to work in as many as we can. And then also a quick change in our agenda. For the first panel, Kabir, Duggal, and Erica McCormick-Dorst are not able to join us tonight, but we are, however, excited to have David Larson. He's a professor at the Mitchell Hamlin School of Law, former chair of the ABA Section on Dispute Resolution, and current secretary for the Ray Corollary Initiative Board of Directors, which pretty amazing. So thank you so much for joining us this evening, David Larson. So to get our program started, I want to turn it over to New York Law School's Senior Associate Dean for Academic Affairs and Institutional Strategy, Matthew Gawal.
Thanks so much. Thank you, Professor Fisher. As you said, I'm Matt Kowal, the Senior Associate Dean at the Law School, and we're so proud to host the 10th Annual Symposium on ADR and Diversity. We're here at the Law School, we're so proud of our ADR program, which is led by Professor Peter Phillips, who, together with colleagues, has done a wonderful job creating and leading the program. Also want to acknowledge Professor Fisher, who has been a part of our community, a really integral part of our community in this area for many years. And of course, to thank the symposium partner, the American Arbitration Association. When we discuss inclusion or having a diverse workforce or student body, comes down to providing opportunities for everyone to be able to enter our profession and succeed in their careers. This is certainly true for dispute resolution practice, which, as you all know, has become a preferred mechanism for resolving a very wide range of disputes. So with this increasing centrality to public and private disputes, satisfactory and fair resolutions must be possible for all types of disputants. Every practice in the legal profession requires the skills of negotiation and understanding the perspectives of others, as we are constantly engaged with colleagues and others with wholly different backgrounds, perspectives, and objectives. Here at New York Law School, central to our teaching approach is ensuring that our students can listen carefully, understand and avoid assumptions and bias, counsel well, solve problems, and be truly effective advocates for all of their clients. And when it comes to mediation and dispute resolution, attorneys who come from a variety of backgrounds and who learn in inclusive environments will achieve the best possible outcomes for their clients. At NYLS, we're so proud of our ADR program, which stresses developing skills through experiential learning opportunities. And our students have excelled, including our dispute resolution student teams that we're so proud of, that constantly win or place at the top of inter-school competitions. It was clear that diversity is a pressing issue in this area. That's why this type of ongoing discussion is essential and why all of us must continue to ensure the promise of legal education is widely accessible. So once again, welcome virtually to New York Law School. We're so grateful to Professor Fisher and our program partners for their dedication and commitment to making this a representative sector with substantial opportunities for a wide range of people. And thank you to all of our attendees for their interest in the field and for engaging in these important conversations. It's really a pleasure to continue to be a part of this event.
Thank you. Thank you. Now let's hear from Jeff Zano, Vice President of the American
Sure. Thanks
Arbitration
so
Association.
great. Thanks so much, Genesis. It's truly an honor to be a part of this program. Hard to believe that we're celebrating the 10th year anniversary. The AAA has been a proud sponsor each year, so we're very proud of that. And I want to extend my sincere thanks to New York Law School, the Dean, Peter Phillips, and our outstanding moderator, Genesis Fisher, who's also the moderator and organizer for bringing us all together tonight. This year, perhaps more than ever, it is essential that we continue this dialogue within the ADR community, very essential. While progress has been made, there's still important work ahead. I hope you find tonight's program engaging, meaningful, and inspiring. So thank you. I'll turn it back over to you, Genesis.
Great. Thank you so much, Dean Kowalb and Jeff Zeno. So we have a wonderful opening panel for you this evening, a look behind the curtain, if you will. Our first panel is called Inside the Room, How Counsel Think About Diversity in ADR. And to get us started, I'm going to turn it over to our moderator, Serena Lee, the President and CEO of the CPR Institute. Serena?
Wonderful. Thank you so much, Genesis. And from New York Law School, if I can invite my first panelists to please join me on screen here. I'll give them all a second. Wonderful. Hello, James and Torsten, if I can. Wonderful. So welcome to all of you. Let me start by introducing myself. My name is Serena Lee. I am the President and CEO of CPR Institute. We are a nonprofit based here in New York. We're a think tank with a mission to help corporations and law firms implement and create dispute resolution processes. And when I was approached by New York Law School to join this panel, I had some time to think about how I might tackle this conversation. And I think about arbitration and mediation, and I think we can all agree that we have a shared promise in this mediation and arbitration to provide parties with neutrality, but I don't think legitimacy in these processes are not necessarily self-executing. And so the question today is whether or not diversity matters, but how it can matter lawfully, intelligently, and without eroding confidences in the processes themselves. Today I have some of what I think is a very stellar panelists to talk on this topic. I will introduce each of my panelists in turn and ask you to just give a short introduction to yourself. So we'll start first with Torsten. Torsten, why don't you introduce yourself?
Thank you, Serena. Thank you for inviting me. My name is Torsten Bartsch. I'm a German and New York bar attorney who's worked for the past 25 years for Caterpillar as Associate General Counsel. And I have law degrees from University of Frankfurt in Germany, from Georgetown Law School in the US. And I'm married to a wonderful woman from Wisconsin. So I've become a Green Bay Packer fan by marriage. So I've been practicing law for over 30 years. I recently retired from Caterpillar and have been involved. My last role was to coordinate all the litigation, mediation, arbitration for Caterpillar in Europe, Africa, Middle East. And so I've been active in those fronts since then. And I am a happy father of a number of kids, and I completely failed as a father because none of them wanted to pursue law as a career. So I'm very happy to be on this panel. Thank you, Serena.
Welcome, Torsten. I should also mention that Torsten currently serves as our co-chair of CPR Institute's European Advisory Board, so he helps with that as well. So, James, why don't you introduce yourself?
Thank you, Serena, and hello from sunny London. My background is slightly less impressive than Torsten's. Where are you sitting, Torsten? It's beautiful. Or is that computer generated?
It's Geneva. It's in Geneva, Switzerland, just outside Geneva. That's the view from the mountains when you go skiing in the morning. So.
Yeah, well, it's lovely. So as I mentioned, I'm calling in from London this evening. I'm a partner in the London office of Jenner and Block, where I practice international arbitration. I'm a New Zealander by background, hence the slightly unusual accent I assume for most of you. But I've spent most of my career practicing in London, although I've had some stints in Asia. I've spent time in Tokyo and Hong Kong as well, and have been very lucky to practice international arbitration across the whole of my career.
Wonderful. Welcome, James. And Professor Larson, please introduce yourself. Oh, you're muted. Well, there, we said it. It can't be a webinar without someone saying you're muted.
Yeah. Oh, I was trying to be polite in the beginning, but I apologize for that. Genesis, thank you for that introduction earlier. At the risk of being repetitive, I'm a professor at the Mitchell Hamlin School of Law, St. Paul, Minnesota. I am past chair of the American Bar Association section of dispute resolution. I'm a current member of the ABA House of Delegates, and I'm still on the executive committee for the section. I am the secretary for the Rate Corollary Initiative, which, as you may know, is dedicated to including as many talented neutrals as possible on rosters for arbitrators and mediators. I've had a number of different appointments, including at the appellate division of the EOC, but I'm very happy to be joining you.
Wonderful. Thank you so much, Professor Larson. So let's get the discussion started. I'd like to start by framing the question of what exactly we're talking about when we say diversity. So I'm going to pose this first question to you, James. Oh, before we begin, I want to just, I have to have the disclaimer that the views expressed tonight are the speaker's own and do not reflect the views of the current or former organizations. So I have invited James to speak on behalf of the outside counsel's POV, Torsten as the inside counsel, and of course, Professor Larson as the academic. So that's sort of the roles they are playing in this discussion. So James, my first question to you is this. When parties say they want a diverse arbitrator or mediator, what problem are they actually trying to solve or resolve? Is it perceptions of fairness, decision quality, legitimacy, access, or something else?
So I'm going to set the scene a little bit to that question and particular perspective that I'm coming from. So I work in big law for a US law firm. I'm based in London and I do international arbitration. So I'm typically representing large corporates in their disputes. And those, we're talking tens, hundreds of millions of dollar type disputes. And so you're dealing with very sophisticated clients. And I think they probably, from that position, look at this question at two different moments in time. And I think that probably gives them two different answers. This type of client tends to have a particular worldview, and they will look at arbitration as a process and how that can improve. How can arbitration improve? That question is usually driven by cost. How can arbitration be cheaper? That's usually the number one complaint. But they will all aspire to a process that has diverse views, diverse participants, because they will feel that that will lead to better outcomes. It will ensure that there is greater legitimacy of the process. It's the general perspective that I think most of us will have, not just in relation to arbitration or mediation, but to society and life itself, that we all aspire to encourage people from diverse backgrounds, and we all see the benefit of that to us as individuals, to society, and the greater good. And so I think all of my clients aspire to that. But they also come to this question a second moment, and that's when their dispute commences. When they're down in the weeds of a big case and they're staring perhaps at tens of millions of dollars of potential loss, they start to become a little more focused, less on diversity, but on what they think their arbitrator will bring to the table. So in fact, they're often looking for someone who looks a little bit more like them. And I don't mean that in the physical sense, I mean that in terms of perhaps comes from a similar legal background, perhaps comes from a similar industry background, has an understanding of the nature of the dispute, has a similar approach to legal issues, all of those things which are more outcome driven than big picture driven. And so at that point, I think clients are perhaps less inclined to look for someone diverse, but when they step back and they talk about the process in the wider sense, I think they're more focused on diversity there. So there's definitely a bit of a dichotomy, I think, at play.
Mm. So, Torsten, you just heard what James had to say. Now, from your point of view as in-house counsel, do you agree with what he said, or is race, gender, age, and geographic proximities, are they proxies for experience and worldview, or do you see them as independent values? How do you see diversity at the first instance with choosing a mediator or an arbitrator?
Right. So thank you, Serena, and thank you, James, for the good comments. I think also try to do it in two parts. First of all, diversity, in my experience as an in-house lawyer, encompasses a number of aspects, not just sort of race, obviously gender, but also national background. And I think James was alluding to that. If you run a legal department and an in-house function, like for a company like Caterpillar, you'd have to make sure that within your in-house team working on these litigations, you have a diverse enough background to represent the diversity of the commercial disputes that we are typically facing. So it makes little sense to have only North American trained lawyers try to manage disputes in Europe, in Asia, in Latin America, right? So from the immediate surrounding of the lawyers touching cases in international disputes, there's definitely has been a strong push in multinationals like Caterpillar to look for a diversity of the lawyers working on that. And, among the criteria that I just mentioned, not just race or gender, but also legal background, common versus civil law, and legal training to better assess the disputes from an in-house perspective. So answer that, absolutely. Diversity is crucial. And I think that's been one of the changes which I've experienced over the years. When I started my career, at Caterpillar, it was still very much a mode of which are the best American lawyers that we can send to these other regions to manage the disputes and try to then select mediators, arbitrators. And that has definitely changed over the years. So to everyone out there as a student, yes, diversity is important if you also look at what international companies are doing. When you go to the second phase and the particular question, now you have a dispute and you are now looking at how to staff a mediation panel or a mediator or how to staff an arbitration panel. I agree with James. It becomes a little more narrow, but diversity still plays a role. I'll give you an example. Let's assume we want to do an arbitration in Latin America. We would not typically have two white male, people based in New York be the three arbitrators for that, because you would work with outside counsel to make sure that you look at the dispute, you look at the other party, and you want to get someone who is also more likely to understand the kind of legal and cultural aspects and shades that this dispute has. So I think it very much depends on the dispute that you have. If you have a big dispute in the labor law area, I think sort of especially diversity also on race and gender plays a bigger role. Then if you have a strict supplier client dispute where you're just looking at who are the good arbitrators or mediators that could help us resolve it. And just one other element, fully agree with James, what's key for the client is not so much to have diversity per se, but diversity as a function to allow us to resolve a dispute, as James has said, cheaply, but also quicker than possible. Because the assumption is if you have someone who better understands the diversity of the legal people involved in the dispute, you have a higher chance that you have a more efficient mediation or arbitration. So it becomes diversity in that second phenomena for me becomes a secondary aspect, an important one, under the goal, how do we efficiently, cheaply, and quickly resolve this dispute?
Yeah.
Thanks.
And you have your hand up.
Yeah, can I just add to that? I
Sure.
think that's absolutely right. I think it's important to recognize that diversity doesn't just mean one thing. It's a very diverse word and meaning, right? And it means different things to different people in different situations. And so that's an excellent example that Torsten gives of working in an American headquartered multinational, that in different parts of that company or in relation to different types of disputes or in the context of a different arbitration, you're looking for a diverse range of people to play particular roles in particular situations.
Well, let me ask you then, you know what, how do you advise clients when diversity is part of the request? I mean, does it come from Torsten, the client, saying, hey, my expectation is that you have a diverse, or is it a part of the strategy unto itself? And does it change between when you select it, when you're in the position of selecting an arbitrator or arbitrators versus mediators?
So I think again it's at two different levels, and some more sophisticated corporates who are involved in a lot of international arbitrations. I've done a lot of work, for example, for oil majors who have very sophisticated policies around dispute resolution. They have large in-house dispute resolution teams. And so some clients that I can think of will actually have a policy that, okay, we have this arbitration, you have to give us a list of 3 candidates, and at least one of those has to be diverse in some way. Now, does my advice change? I don't think it does. I think my role at that point is to provide the candidates that I think are best suited to this particular dispute, given the subject matter of the dispute, given the governing law, given the timeframes involved, given the parties on the other side, all of those things. So we will still go and search for our arbitration candidates in that same way, but within that, we may try to find the diverse candidate that still fits those things that we're looking for. And I guess what I'm saying at that point is you're not trying for diversity's sake. At the end of the day, you're still there to advise the client. You have a duty to advise in the best interests of the client, and ultimately that means winning the dispute. So you're always looking for the arbitrator that you think is best suited to the case.
Mm-hmm. So, Professor Larson, you've been listening to our inside and outside counsel talk about how they perceive and consider diversity when selecting an arbitrator or mediator. So then let me ask you, in light of the Supreme Court ruling of of course, Students for Fair Admissions dispute, what do you see as the status of diversity or engagement or inclusion in the U.S. and how? Tell us more about where you stand from, what your perspective is from the U.S. side.
There's a lot there to unpack.
It really is. It's a broad question, and you have a good 9 minutes to do it.
Well, just keep in mind with that Supreme Court decision that, the Supreme Court did not say that race cannot be considered as a factor, that somehow it's got to be taken out of the equation. It just kind of reframed it as a way you are able to consider it. Consider it in terms of someone's life experiences, for instance. Don't make it a kind of a black and white yes or no kind of criteria quota item. But I don't think that diversity, equity, and inclusion are prohibited terms anymore. I just think that we have to be strategic about how we're thinking about them. As I mentioned in the introduction, I am secretary of the Ray Corlier Initiative, And at one point, our mission was dedicated to diversifying rosters of neutrals, arbitrators, and mediators. We've kind of reframed that a little bit, that our mission is to utilize all the talent available, which I think is a good reframing, because if we're thinking about the goal here is to utilize all the available talent, then really it's a win-win for everybody. It's increasing participation for underrepresented parties on the one hand, and you're giving the disputants, the participants, the opportunity to pick the best possible person. When we look at businesses like Indeed and recruiting agencies, what they're selling, basically they're selling is a large pool of possible applicants for whatever task you want. They are basically selling diversity, and they're not framing it that way. But typically, when you're trying to choose someone to perform a service for you, you would like to be able to choose from as many qualified people from within, or choose between as many qualified people as you can. So I think as we think about diversity, that if we talk in terms of inclusion, people will be less polarized when we use that term, but I think we get to the same place. And I think it really more accurately identifies the goal of including as many talented individuals as we can and allowing the selectors the biggest choice available.
Fantastic. Now, I had chosen James and Torsten not because they're fantastic speakers, but partially because I was interested that since they come from an international ADR framework where diversity is actually not only expected, but sometimes mandatory in the selection of arbitrators in the constitution of an arbitral panel. I thought it would be an interesting interplay, because here in the US, there's now talk whether or not you can consider diversity as, the D word, whereas we have another jurisdiction out there, the rest of the world, where it's a given. And I do like this conversation where we talk about diversity in a more thoughtful way and not a polarizing, politicized way. I want to ask, maybe might be a slightly, not controversial, but maybe for food for thought. Do you think that mediation selection should tolerate more subjectivity than arbitrator selection? And if so, why? Of course, that is on the assumption that mediation is, fully, party autonomy and so forth, and that they are decision makers. I'm just going to throw that out there. I'll start with you, James, since you're probably out there choosing lots of arbitrator or mediators.
So from my perspective, I don't think so. I think I approach the appointment of a mediator and an arbitrator in the same way. Save that when you're talking about a panel of three arbitrators, you perhaps have a bit more freedom of choice in that you get to appoint your one arbitrator, and you do that with an eye on who you think that arbitrator might in turn favor as the chairman or chairperson of the tribunal, and how they might get on with the other side's appointees. So there's a bit more game playing, so to speak, and that gives you more scope for considering different characteristics, perhaps. Whereas where it comes to a mediator, it's just a one-off agreement with the other side on who that mediator would be. In my experience of the type of work that I do, that mediator is typically appointed by agreement, not by an institution. But ultimately, I'm looking at the same characteristics, giving the same consideration to how I think they will approach the case, how they will react to the other side, to our arguments, do they share our legal background, our legal perspective, those sorts of things.
Now,
Yeah.
Torsten. Oh, no, go ahead, David.
Yeah, sorry.
I was just say, I've been both an arbitrator and a mediator. I think the considerations are important for both, but I suggest that maybe the kind of subjective considerations are maybe a little more compelling when we're talking about mediation, where people are really concerned about empathy and the ability to communicate and their emotional intelligence and their interpersonal style, that they're really concerned about those kinds of things when they're picking a facilitative neutral who's not going to grant them an award. And when they're thinking about their arbitrator, there's maybe a little bit more of this kind of objectivity in terms of this person going to be able to evaluate the facts for me and be able to reach what I think is a fair conclusion. I think it's a matter of degree for sure, that it isn't a yes or no. But I think that if you're asking me, I think that maybe those softer, more subjective considerations for many are more important in mediation.
Right. I think I'm trying to build a bridge between the good comments of David and James, which I agree with. If you look at from a practical perspective, from an in-house perspective, if you look at trying to populate one of three arbitrators in a complex dispute for a multinational, the kind of arbitrator you're looking for often starts with someone who has a lot of subject matter experience, or especially the more complex the dispute is, the more you're looking for sort of gravitas in the sense of understanding that kind of litigation or that kind of dispute and coming to a solution which is arguably more favorable to your own party's position. You're not so concerned about other aspects of the diversity initially. Whereas on a mediator, it's one person. It is not quite as important that the mediator is fully immersed in the subject matter of the dispute, but that the mediators has the skills to allow the two parties to come together, because the main purpose of mediation is, of course, to avoid a multi-year, very costly litigation or arbitration process. And so I've had some experience with people, with good mediators who didn't necessarily were known as an expert in the field that the dispute was about, but they were just very excellent, like David has said, in the ability to get people to understand what's behind the dispute and to find a process which allows the two parties to come together. So I think I agree that there's more on the subjectivity front. I'm not sure that was fully your question, Serena, in the sense that is a corporate more willing in a mediation to say, oh, I maybe have an internal target or not, to have a certain diversity roster. And, if I have 10 mediations, I want to have 4 or 5 mediations led by a woman or by a person of a different cultural background. I don't think that plays as much of a role as the other elements. Is that mediator is the diversity that the mediator represents, from an individual perspective, from a cultural perspective, from a perspective of experience. Is that something that helps for the dispute? And again, I'm using the example, you have part of the multinational, you're based in Europe now, you're in Spain, right? And you have a dispute in Spain between the multinational subsidiary in Spain and a Spanish supplier. Am I going to choose? My choice is not between an African-American woman from California and a white-haired man from New York. I'm going to be looking for whoever is the best mediator on the social skill side, who understands the Spanish culture and that aspect, right? So their diversity is very important, but it is driven by the dispute and by the location of the dispute and the context. Because at the end of the day, as a corporate, I probably have one shot at a mediation, at least initially, and I want to make sure that the background of the dispute matches the profile of the mediator.
Yeah, Serena, you alluded to it earlier, this idea of perceived legitimacy. I think that's a real concern, a real interest. And when we talk, regardless if we're talking about mediation or arbitration, I think we need to pay attention to perceived legitimacy because we're talking about ADR processes. So unlike a court decision where the enforcement is pretty overt, what's going to happen with a court judgment. It's less overt when we're talking about mediation and arbitration, and that the kind of the durability of that result rests in large part on the kind of perceived legitimacy of that decision. So if you don't trust your arbitrator because you believe that you may be subject to bias, either explicit or maybe unconscious bias, if you have the same kind of concerns about your mediator, that's going to really affect the durability of that decision. So I do think it's an important concern in terms of the lasting effect of any kind of a resolution.
So let me ask the panel this: does emphasizing diversity in
Sorry,
arbitration?
Serena, can I just jump in very
Sure.
quickly to offer the first CLE code?
Oh, sure.
Okay, great. So again, thank you everyone for participating today. I just want to offer the first CLE code word today, which is counsel. The word is counsel. SEO, counsel SEO. Great, thank you.
Sure thing. Let me ask the panel this question. Does emphasizing diversity in arbitration risk signaling bias, or does ignoring it risk eroding legitimacy? And of course, I'm thinking about the Jay-Z arbitration case whereby Jay-Z had essentially stated that he found it objectionable that none of the arbitrators that were presented to him in his arbitration were African American. So there, I just want to invite the panel to talk about that. So here is a situation where, we've ignored diversity according to the plaintiff. So what of that?
Well, it's not hypothetical. I mean, he got a temporary restraining order. So there was a legal impact from that concern. He pointed kind of the numerical disparity. I think there are 200 arbitrators on the list. There were 3 African Americans and one was conflicted out, so there are only 2 available. And the court felt that, there's a TRO and we need to investigate this further. The case eventually settled, but that was a real legal implication from that concern.
Can I ask a question about that case?
Sure.
I don't know what arbitral rules it was under, but was it a requirement of the rules that he had to nominate someone from a given list?
Well,
Because
actually, Jeff Zano, I don't know if you're on if you want to join this conversation.
I am on, yes. Actually, it's incorrect. The list that we sent out was 50% diverse, and we had on our panel in 2018, I think 180 African Americans, so African American males, I think, somewhere around there. So there was a lot of the reports in the news were incorrect, if that makes sense.
yeah, well, it does, but also I can see a concern if he's given a list that is limited in the way he suggested, and I take on point your comment about that. But only if the rules require that he appoints from that list, because otherwise he has the whole world to appoint from.
Yeah, well, the
Right.
rules do require that. Yeah, we put together the list, and you're required to number, rank, and strike.
Okay.
And so, yeah, you're required to use that list. But again, that list in 2018 was 50% diverse. And I believe on that list of 15, there's 2 African American males on that list. So
Okay.
I will beam out.
Yeah.
We may beam you back in, so
Oh.
stay close.
I'm staying close.
Yeah, and just so I understand, so why was the TRO granted?
Oh, because the wife of the judge passed away, and he passed it on to another judge, and she granted the TRO simply because she said you're going to have to address this issue later on. She wasn't crazy about the arguments that were being made by the law firm, by Jay-Z's attorneys. But she said, listen, I'll grant this TRO. It'll be taken up by the judge that stepped aside for a few weeks. That's why. And the case ended up settling. Yes, we ended up sending out a second list. This I can talk about it because this is all documented. And for the audience, if anyone wants to read about this case, it's really fascinating. Just type in JZ and arbitration, and up will come up the documents that we put together for this case and the things that we dealt with. You'll see all the court papers.
Yeah, and I don't want to call it a question. Your rosters. I'm only pointing to the fact that right or wrong, it led to a legal challenge that resulted in a TRO that perhaps shouldn't have been granted.
Yep.
But the fact is, there was that legal consequence.
There was, yes, there was, and we've seen the consequences since. And the silver lining of that case is that we're still talking about it. It's one of Serena's questions, and that's a good thing. We're talking about it as in the need for diversity in this area. I speak on this case probably about 5 or 6 times a year. I've done podcasts on the case and things like that. That's the silver lining.
So then maybe since we've brought up the institutions, where do institutions either support or meaningfully constrain these choices? I mean, from your point of view, outside counsel, James, what is your expectation, or is there a expectation or a desire for the institutions to help in diversifying the list or of candidates? In instance when you have a list generated.
I mean, there's a simple answer to that, and it's yes. Institutions play a very, very important role in publicizing and supporting the legitimacy of arbitration. And when it comes to panels of arbitrators, I think that's a very important role they can play in ensuring that they have a diverse panel of arbitrators available to people. I think in the world I operate in, most of my arbitrations, you have freedom of choice to appoint whoever you want. So I do think it's incumbent on users of arbitration to make decisions sometimes around things like diversity. If they really genuinely want to promote that. But right back to my first comments, I think sometimes when the push comes to shove and they're in the middle of an arbitration, those considerations sometimes go out the window. There's a very similar issue, I think, with costs in arbitration. Very regularly, almost every seminar you're at, someone will complain about how when they started out 20 years ago, arbitration, one of the great benefits of it was the speed and the efficiency and the cost. And now they've just come out of this hideous 3-year process that cost millions and millions of dollars, and they didn't enjoy it. But many times when you talk to clients about that and they have that view, when push comes to shove and they get into the arbitration and you ask them, well, do you want to run that argument? Should we go down that rabbit hole? And many times they'll say, yes, we must. And it's client driven, your approach to the arbitration. And so it strikes me there's a lot of similarities between that and the diversity question. On the one hand, yes, for the greater good, we all want that. But for our particular case, maybe we don't. And so, again, we come back to that dichotomy that I often see.
I'm glad you say that because, I have 20 years working as on the provider side and recruiting lots and lots of good qualified, diverse arbitrators onto various rosters. And I say, I can keep on feeding the pipeline, but they must be ultimately selected by the parties themselves. So yes. Torsten, you just heard what James said. It's your fault.
Right. I mean, I'm happy to take part of the blame, but the question at the end of the day is, sort of, it goes back to the role of what we have as in-house counsel and as legal department towards our client, right? our primary objective is, as in-house lawyers, to provide the best legal counsel and risk management for our company. And our primary objective is not per se to advance any part of diversity or non-diversity, right? So, if comes, I cannot imagine a situation where a GC or associate general counsel of a multinational or another small company says, "Oh, I would like to take person A because I think he or she may be the best for the job, but I'm taking person B because I want to advance diversity per se." That's not going to happen, because that we cannot justify towards our senior management, towards our shareholders at the end. Having said that, I've experienced myself that there has been an increased diversity over the past 15 years or so, which I think is good and which I experienced as a positive development. So I think it's let's put it that way. The more if past efforts of diversity encouraged more people who were traditionally underrepresented to enter into legal careers, to enter into roles in in-house counsel or outside counsel, or become judges and build up reputations and then become potential mediators or arbitrators, I think that's a good thing. I mean, my experience has been quite positive. I don't think I've experienced for instance, an all white male panel on arbitrations in recent years for us, which would work in any of the international contexts. So yes, so to speak, be patient. Don't expect the in-house counsel to be on the forefront. I don't think that could be our role, but to work with us to make sure that they're, like to work with the institutions like you've done, to make sure that there's enough choice. And I can think of one suggested list of mediators which our outside counsel gave us a couple of years ago, and it was not particularly diverse. And then we went back and we said, hey, we noted these are all sort of very similar profiles of people that you offered. Could you give us someone else who has a slightly different background and approach on this? And they came back to us, and that was helpful. That made our job internally easier. Yes, so I would say it's an incremental steps. Serena, I just noticed there's a couple of questions in the chat. I don't know if we want to respond.
Can I just add something to that?
Yes.
And what is coming through from everything that Torsten says is he's very, very experienced and very, very sophisticated, and he's able to therefore evaluate the different characteristics and the importance of those to the particular case in a very sophisticated way. One thing that always used to frustrate me is not the firm I'm in now, but the prior firm that I was in, which was a very big international firm, literally offices all around the world. And while I was in the arbitration specialist practice team, there were others around the firm that would do arbitration at the smaller value mark. And it used to drive me crazy because you would get an email from them saying, James, I've got this arbitration. It's value X, relatively small, not very complex. And I'm thinking of some arbitrators, and here's my list. And it would be Jan Paulson, and people like that. And you're just thinking, well, number one, I can tell you he's going to say no to this. But number two, he's not the right person to be thinking about for this case. And actually, you've got a case that's of limited scope and size and complexity. And actually, you've got greater scope, therefore, to give thought to some of these more subjective characteristics, give an opportunity to a young, eager arbitrator who's really going to take that case and run with it because it's their opportunity. And so I do always encourage my colleagues and those around me who are perhaps a little less sophisticated, to take a step back. sometimes and think about it a bit more deeply.
Serena, building on something Torsten said, I'm looking at one of the questions that you posed early on for us to possibly talk about. At what point does diversity become too imprecise to guide selection decisions? When I saw that, I thought, man, cross that bridge when we get to it. We just, that's just, we're not there. It's not even a consideration. And listening to Torsten say that you're not going to make a decision based on that exclusively. I don't know if we're ever going to get to that particular point where we're going to have to say that because it's become so determinative in our decisions that we have to worry about the imprecision of this motivation, of this criteria. I don't know if we're certainly not there now, and I don't know if we're ever going to get there. That's just
Well, I know that we have some questions from the audience. So why don't we have a few minutes, and I do have a closing question, but in the interest of addressing some of our audience questions, should we start with tackling some of these questions?
I'm
Sure,
happy
I
to
think.
pose a couple. Oh, go ahead, Torsten.
Yeah,
And
I mean, I quickly scanned them. I see there's questions which are a little bit similar. The one was, do you consider co-mediation in cross-border disputes, one for each country? And then there's two questions about language diversity versus translators. Again, I mean, I can try to have a quick stab at that. In my experience, co-mediation, whether in a cross-border or non-cross-border case, is relatively rare, and it's almost like most of the mediations that I've been privy to and that I've experienced seem to have the notion it should be one mediator, and I'm not sure I'm personally very happy with that. Because I think your two mediators, especially either in a cross-country, cross-border dispute situation, or in a matter which has a certain complexity and diversity. I mean, diversity of parties. If you have more than just two parties, it can be much less. It can be a lot asked for one mediator to try to comment there. So in a way, I would wish we would do more co-mediation, but in practice, I haven't seen it. I'd be interested to hear the others. On the linguistic side, I think that does play a role. So in the mediations and arbitrations that we've looked at, you obviously have a prevailing contract language and a language in which the dispute is being managed, and also the mediation takes place. So obviously, if you have an English mediation, you would have to have someone who speaks English very well. It doesn't have to be a native speaker, because one of the things that I found, and that goes to the language diversity, in every mediation that I've been part of, and some of the arbitrations, there's moments, of breaks. There may be opportunities for party representatives to talk to each other, and there's often a different language in the international disputes, which is at stake. Spanish, German, French, those are the main ones, but I imagine the same as in the Asia theater. And in those cases, we do look, as a corporate client, we do look for mediators who are able to engage in the native language with the principle of the other side on a limited basis. So yes, I would say the language abilities of our mediators or arbitrators does play a role and can be a factor, even if the prevailing language may be English. I hope I've answered, at least from my perspective, those three.
My experience is precisely that. I've not seen co-mediation in practice at all, although, as you explain it, it could make sense in different types of complex cases, to have those different points of view. And I've always thought it must be a lonely role to be the mediator, because you have to take in and digest a lot of information, a lot of emotion, and to be able to go into a room and discuss that with someone else and agree an approach. There must be some benefit to that, in the right case. And certainly with language, yes, language considerations, even when there's only one language of the arbitration, are very important. of a case at the moment which involves a dispute out of Mexico with largely American but some Mexican parties involved. And we have a fully European tribunal of 2 Spaniards and a French national, but they all speak Spanish, even though the language of the arbitration is English.
The only, I'm sorry.
No, go ahead.
I was just going to say, I don't have a lot of experience because I'm not trilingual, but I've done a lot of work with the disability community, and I've done mediations with hearing impaired, speech impaired individuals. So we've had to relied on American Sign Language, and as a mediator in this situation, and I'm not fluent in American Sign Language, I've often felt that I wish I were. Because in mediation, I do believe that in being able to find distinctions about communication and about understanding emotions and perceptions is so critical, more critical than in arbitration. And when we're talking about language diversity versus translators, having to rely on an interpreter as opposed to being able to understand the disputant myself directly, I think I'm at a disadvantage. And so I would agree with both Torsten and James that if you have language diversity in the language of the dispute, that's and your neutral has that ability, that's an advantage.
Mm-hmm. Well, I see we are actually at time. I knew this conversation would be very robust and we'd have too much to talk about. I see that we have additional questions, which we will try to get to, but I want to thank my panelists for this engaging conversation. I know there are lots of other conversations and speakers following us, but hopefully this will at least have whet everyone's appetite as to how diversity is seen in the ADR world from the users and from the academic point of view. So thank you so much, gentlemen, for your conversation.